I'm very pleased to welcome Gillian Crew onto the channel. Gillian is a barrister from 42 Bedford Row, and one of Gillian's key practice areas is employment law. Gillian is going to talk to me about whistleblowing, and in particular, disclosure of information. Thank you very much for joining me, Gillian.
Thank you very much for having me, Matt, and for giving me a talk to waffle on about whistleblowing. As Matt said, I'm here to talk about whistleblowing and in particular about disclosure of information. So whistleblowing, what do we actually mean when we say whistleblowing? I think that whistleblowing is a concept that non-lawyers and lawyers alike think that they know and they think they understand what it is. And that's partly been helped by the presence of high-profile whistleblowers in the press. So that's led to an increased awareness of the protection for whistleblowers. So think of people that you will have heard of, like Edward Snowden, Chelsea Manning, Julian Assange, to name but a few. But what actually is whistleblowing? Put simply, whistleblowing claims are the legal protection which exists for people who blow the whistle on wrongdoing in organisations or in their employment. Protection exists from being subject to a detriment, so somebody doing something unpleasant or unfavourable to you, or being dismissed. But again, what do we actually mean by blowing the whistle? I'm going to talk about what this actually requires, namely the disclosure of information. But first of all, I'd like to put things in some context and explain how we got to where we are today. So where did whistleblowing protection come from? It comes from the Public Interest Disclosure Act 1998, which came into force on the 2nd of July 1999. That of itself is a very short Act of Parliament. It consists entirely of amending provisions, in particular to the Employment Rights Act 1996, which is where we find today the framework for whistleblowing claims. It is a very short Act of Parliament, but it had massive ideas. It was introduced actually quite unusually as a private member's bill in the light of disasters such as the Brugger Ferry disaster and the Clapham train disaster. Both events were disasters where blowing the whistle may actually have prevented the disaster occurring. The title of the PIDA Act gives an idea of what it's set out to do, and it says this: it's an act to protect individuals who make certain disclosures of information in the public interest, to allow such individuals to bring action in respect of victimisation and for connected purposes. Now, those laudable aims were introduced by putting specific rights into the Employment Rights Act 1996. As I've mentioned, the right not to suffer a detriment for making protected disclosure, that's to be found in section 47B of the ERA. The right not to be unfairly dismissed for making such disclosure, that's in section 103A. And following recent changes, a right not to be subject to a detriment by your colleagues within section 47B 1A. So the statutory framework, and you'll notice that the statutory framework in the ERA doesn't talk about blowing the whistle. It talks about a protected disclosure. It talks about a qualifying disclosure. And what is that? A qualifying disclosure will be protected and means that any disclosure of information, which in the reasonable belief of the worker making the disclosure is made in the public interest and tends to show one of the following 6 things. And the following 6 categories are very important. That's the actual blowing of the whistle. So the first category is that a criminal offence has been committed, is being committed, or is likely to be committed. Secondly, that a person has failed or is likely to fail in complying with a legal obligation to which they're which they are undergoing. And that's particularly important as a lot of cases use that category because the legal obligation can refer to somebody's contract of employment. Third category, miscarriage of justice has occurred, is that the health or safety of any individual has been, is being, or is likely to be endangered. Fifthly, that the environment has been or is likely to be damaged. And then finally, a catch-all, information tending to show any of the matters in those 5 previous categories is being or is likely to be deliberately concealed. So who has to disclose this information? The protection applies to workers within the meaning of section 233 of the ERA. And that's not just employees, but anybody that's in a contractual relationship. It is a wider definition. It can include people that we often don't think of as workers. So partners of law firms, in the case of Clyde & Co. and Bates van Winkelhoven, even judges now can avail themselves of the protection, thanks to the case of Gilliam and Ministry of Justice that took place in 2020. However, there has to be a contractual relationship. So the poor rector in the Bishop of Worcester's diocese, in the case of Sharp and Bishop of Worcester, was found not to have a contract in existence, so he wasn't a worker. But focusing in on the really important stuff and the meat of what I want to talk about and for us to think about is, what is the actual blowing of the whistle, this disclosure of information? There's often a conflict between a disclosure of information versus an allegation. There's been a lot of case law on what will qualify as a qualifying disclosure, blowing the whistle, in the above categories. The starting point for our talk on this is to look at the case of Gedald and Cavendish Munro Professional Risk Management. In that case, the Employment Appeal Tribunal reminded us that there must be a disclosure of information rather than simply making an allegation. And there is a distinction to be drawn between communicating information and making an allegation. In that case, solicitor's letter alleged that their client, who was a shareholder, had been unfairly prejudiced by the company. The Employment Appeal Tribunal had this to say, which I think is very helpful background. Further, the ordinary meaning of giving information is conveying facts. In the course of the hearing before us, a hypothetical was advanced regarding communicating information about the state of a hospital. So communicating information would be, the wards have not been cleaned for the past 2 weeks. Yesterday, sharps were left lying around. Contrasted with that would be a statement that you are not complying with health and safety requirements. In our view, the latter would be an allegation, not information. In the employment context, an employee might be dissatisfied, as here, with the way he's being treated. He or his solicitor may complain to the employer that if they are not going to be treated better, they will resign and claim constructive dismissal. Assume that the employer, having received that outline of the employee's position from him or from his solicitor, then dismisses the employee. In our judgment, that dismissal does not follow from the disclosure of information. It follows from a statement of the employee's position. That case was followed by the case of Good and Marks and Spencer's PLC. That case was a case about proposed changes to an enhanced redundancy payment scheme. The EAT held the expression of an adverse opinion in that case that Mr. Good was disgusted with the proposals about the employer's proposals would not amount to the conveying of information. So here we have conveying of information versus making of an allegation or indeed the expression of an adverse opinion. However, in the next couple of cases that we're going to look at, we can see that the case law moves on and the Employment Appeal Tribunal reminds us that we should not be applying a too technical approach and that we need to focus on the wording of the statute. In the case of Western Union Payment Services and Anastasio, the EAT looked at the cases that we've just discussed, Cavendish, Munro and Good, and they observed this: the distinction can be a fine one to draw, and one can envisage circumstances in which the statement of position could involve the disclosure of information and vice versa. The assessment as to whether there has been a disclosure of information in a particular case will always be fact sensitive. In other words, that's not very helpful guidance from the Employment Appeal Tribunal, because really it's dependent on what was on a case-by-case basis. This approach was supported by the Court of Appeal in the case of Kilrain and London Borough of Wandsworth. The Court of Appeal approved the EAT, holding that the tribunal had been justified in rejecting the employee's claim of having suffered a detriment as a result of making protected disclosure, and looked at the case of Cavendish Munro and stated this: I would caution some care in the application of the principles arising out of Cavendish Munro. The dichotomy between information and allegation is not one that is made by the statute itself. It would be a pity if tribunals were too easily seduced into asking whether it was one or the other, when reality and experience suggest that very often information and allegation are intertwined. The decision is not decided by whether a given phrase or a paragraph is one or rather the other, but is to be determined in light of the statute itself. The question is simply whether it is a disclosure of information. So the Court of Appeal are reminding us to go back to first principles, look at what the statute says, the ERA, namely, has there been a disclosure of information? And the next case I'm going to discuss is a good example of where there is an intertwining between an allegation and the disclosure of information. And that's the case of Eiger Securities and Korshunova. This was a case in which the employee had stated it was wrong for her manager to trade from her personally designated computer without making it clear that she was not the person making the trade. If the statement had stopped at that point, that might have been no more than an allegation of wrongdoing, i.e., it's wrong for you, manager, to trade from my computer, because there's an allegation there. The employee is not setting out in the ways in which it was wrong. However, on the facts of IGA securities, there was new information, and that new information that was conveyed was by the employee telling her manager what her clients thought of his behaviour. So there we have an allegation, but we also have information being conveyed. So there's an example of a situation in where there's both allegation and information being intertwined. So this is a classic case where the Court of Appeal guidance in Kilrain needs to be applied. On the facts of that particular case, the tribunal had not erred in concluding that the employee had conveyed sufficient and had disclosed information within the meaning of Section 43B. And just before I leave the case, I would simply leave by referencing the case of Babula. And that was a case in which it was held by the Court of Appeal that the legal obligation that the employee or the worker thinks that they're disclosing information about doesn't even need to have existed. In that case, Mr. Babula was an American business studies lecturer. He was told by his students that his predecessors had divided his class into Islamic and non-Islamic students, and had told his students that he wished a September 11th incident would occur in London. Mr. Babula believed that this was a threat to national security and at least a threat to incite racial hatred, and he contacted indeed the CIA and the FBI and informed his employer that he was doing so. This disclosure led to a series of acts which caused Mr. Babula to resign and claim constructive unfair dismissal on the ground he made a protected disclosure. The claim was initially struck out for having no reasonable prospects of success on the basis that the facts showed that at the time, incitement to religious, not racial hatred exists, and that there was no such crime at the time. But the Court of Appeal said that that was the wrong test to be applied, and it didn't matter that the legal obligation did not of itself actually exist. So, looking at what amounts to protected disclosure, looking at the disclosure of information, let's think about a few examples of this, where some practical examples of distinctions that we can draw between making an allegation, expressing an adverse opinion, and actually disclosing information or conveying facts to your employer. So, for example, workers saying to their employer, "You're causing me stress at work." That seems to me that's a straightforward example of an allegation. But if the same worker were to say, "I've been diagnosed with depression and I'm taking antidepressants because of my manager's refusal to deal with my complaints of excessive workload," now that would be the conveying of both facts and disclosing of information. So, by way of conclusion, I'm going to finally stop waffling about whistleblowing, but when you're looking at blowing the whistle, or you're looking to see whether the whistle has been blown, remember that the statute doesn't talk about blowing the whistle. It talks about a disclosure being protected, but only if it discloses information. So in other words, if facts are conveyed, not an allegation and not an adverse opinion. So I think I'm going to pause there and thank you very much for listening to my short talk on whistleblowing and what makes a protected disclosure, in particular focusing on the disclosure of information. Matt, thank you very much for having me.
Gillian, that's great. Thank you so much for coming on the channel. It's really helpful to provide the distinction between an allegation and providing information. So thank you very much. And I'm sure that a lot of people will find the video very helpful. So thank you. For more information, do browse this channel and visit my website. Remember that this video is for guidance only and should not be relied upon for specific advice. Also, the law can change. And finally, please subscribe to this channel for updates.